by the Punch TV. So much and then the first time I do her channel here. Subscribe my and like and share. We will switch our share our comment section or for my ebusian for some lamina say a political trending story be up to for much say ebusian for a gentleman. Just say after baby will be a can ebusian for my uncle near uncle video name right by a munchimuna ever play.
Dismissed a preliminary legal objection from NDC parliamentary candidates for Tema Central, Abi Bright for Kaikwe Central, Baba Sadiq, Christopher Bayre for Techiman South, and Irabna Obeng for Ablekuma North. Against the mandamus applications from 4 NPP parliamentary candidates, the NDC had earlier raised preliminary legal objections from NPP asking the court to compel the Electoral Commission to collate and declare parliamentary election results. The court, presided over by Justice Forsenba Ajapong, fixed the date after hearing submissions from lawyers of the NDC, and some responded to it by the EC and the NPP side. Godwin Eduji Tamilklu, counsel for the NDC parliamentary candidates, who are the interested parties in this particular case, argued that the applications seeking to compel the EC to collate and declare elections that have already been declared is a defective and incompetent one. Our legal affairs correspondent, Mutala Inusa, joins us. Let's get more updates from our legal affairs correspondent, Captain Mutala Inusa. Mutala, what more can you report at this time?
Well, Ali, like you rightly mentioned, the preliminary legal objection raised by the 4 parliamentary candidates of the new NDC, I might say, Abi Bright, Baba Sadiq, Irabna Obeng, and then Christopher Bayre, have been overruled by the court. Remember that yesterday, before the application for mandamus seeking to compel the Electoral Commission to perform its lawful duty, the respondent, the interested party, which is the NDC side, the objection was to the effect that if you look at the nature of the mandamus application before the court, it is one that has come by way of an election petition in disguise. Again, they are saying that the application is not competent and the jurisdiction of the court has not been invoked. They made copious references to the PNDC law, particularly with section 284. Especially section 16 and 20, which talked about how elections are supposed to be organized and whoever is aggrieved, the processes that you need to activate to be able to challenge the process. However, yesterday, the court adjourned the matter to today, and before the court adjourned the matter to today, lawyers of the applicant, that is the NPP side, also opposed to that particular objection and said that at this particular point in time, there's no resource that will be challenged. And so once they disagree with whatever election processes that were going on in the constituency, the processes to come to court is by way of judicial review in the nature of mandamus. The EC also corroborated that. Justice Banforcing today, the only onus he had is to make a determination as to whether or not the objection should be upheld or overruled. And what the court said was that if you look at that section, the PNDC law that was quoted copiously yesterday, it was very clear that, look, until such time that the elections are gazetted, the election results are gazetted or published in the Gazette, an applicant or any party who is aggrieved can come to the court. You have other processes to come to the court for a remedy, and one of the processes is to come to court by way of a judicial review. So that particular mandamus application, which formed the basis of the objection has no merit. The parties or the applicants, that is the NPP side, are properly before the court with the application for mandamus solely because the verdict or the results of the parliamentary elections have not been published in the Gazette. Consequently, that particular objections were overruled by the court.
But in essence, what does it mean? Can anybody seek review of this ruling?
So what it means is that now the way is clear for the substantive matter, which is the mandamus application, to be heard. Before I came out to engage you, lawyer Gary Nimakun was on his feet, and he picked out the Tema Central constituency where E.B. Bright and Charles Forson are having issue. And I said, look, the order should be on the Electoral Commission and also to the IGP. The Electoral Commission, because it is the body mandated to conduct election, collate and declare the results. So they should collect all the constituency results and declare who the winner really is in relation to that constituency. So that is the argument that lawyer Gary Nimakun was making just before I came out here to engage you. And like you mentioned, it's going to be a very long day because they have made that indication to the court that they're going to move the applications one after the other because some of them have their unique issues, and that will have to be highlighted. The NDC side have also made it clear to the court that they will also want to deal with their issues one after the other. They have some videos that shows declarations being made by the EC's returning officer, and they want to bring to their attention all these instances for the court to make a determination of that. But one interesting thing, Lily, is that the court is saying that whichever way the parties decide to argue their case in court, the court is willing and prepared to have them go the way they want. But ultimately, the court will have to hear all of them and at the end make a determination as to whether or not the mandamus application now, which is being heard, should succeed or not.
But Murtala, I want you to give us a bit of education. I'm sure viewers listening are hearing mandamus application and they're wondering what really do you mean by that?
So what exactly it means by a mandamus application is that, first of all, what one needs to understand is that what is the function of the Electoral Commission? And per the law, the Electoral Commission is the body that is mandated to organize an election in this country. Once they organize the election, they need to collate and declare who the winner is. That is a constitutional duty. So what the applicant is coming to court by way of mandamus is that, yes, we know that the EC has to perform all these functions as we speak, that those constituencies are hanging, the elections have not been collated, winners have not been declared. So compel them to perform their public function. So it is an application seeking to compel or seeking to demand that the EC will go ahead or force the EC to go ahead to collate and declare winners of those constituencies. So basically, a mandamus application is that you are coming to the court for the court to compel a public institution or a public institution, of course, to perform its public function in respect of a public duty.
But Murtala, in all of this, was the courtroom packed? What was the reaction of parties involved, especially from the NDC side?
Of course, Lily, it's been a very packed courtroom, like yesterday we reported, but you can see that per the numbers yesterday, a lot of people were allowed into the courtroom. This time around, you see a couple of them outside, because of the arrangement that have been made. The people you see in the courtroom today, most of them have to be lawyers, most of them have to be the individual parliamentary candidate, and then they are constituency executive, and of course the media, who are fairly represented. And of course, we do not have official reactions yet in relation to the objection that have been overruled, because immediately that happened, the substantive matter ought to be called for the court to deal with it. But a couple of them are outside here having conversations with themselves and hoping that at the end of the day, something very productive will come their way, by being with the NDC or being with the MPP. But what is clear now is that the court now is hearing that mandamus application, a request seeking to compel the Electoral Commission to go and collate and declare winners. But as to whether the court will grant that, at the end of the day, that will be made clear.
Absolutely, and we'll tell our viewers when that is made clear. Thank you very much. That's Murtala Inusa, legal affairs correspondent.
Now, today on the Channel 1 newsroom, we bring you highlights of what happened in court and also reactions from all the parties involved. But first, let's go over to my colleague Hansen Ajman, who sat in court throughout the proceedings.
The NPP, the Electoral Commission, and the NDC came to court on 4 constituencies: Techiman South, Okaikwe Central, Ablekuma North, and Tema Central. The plea of the NPP, who are plaintiffs in this matter, is that the court should order the Electoral Commission to go back and collate results in these constituencies. These constituencies already, the results had been declared for the NDC. The NPP earlier came to the court for a mandamus application that calls for a collation, or what has become to be termed as recollation. After that, these constituencies were declared in favor of the NPP, except for the Ablekuma North constituency, where the officers were not able to complete the collation exercise. However, the NDC went to court saying that at the first time when the mandamus application was being heard, their arguments were not listened to, and that their right to natural justice, which is a right to be heard, was not upheld by the court. As a result of that, the Apex Court decided to quash the decision of the High Court. The Apex Court, however, directed the parties to return to the High Court to rehear the mandamus application. But before that application could be moved, the NDC's lawyer, Godwin Eduje Tameklo, moved a preliminary objection, arguing that the court lacked jurisdiction to hear the matter because of the approach that the NPP used. He argues that if you look at Section 16 and Section 20 of PNDC Law 284, People Representative Law, as amended, any issue as to whether or not a person has been validly elected or as to whether certain results should be cancelled can only be made by way of a petition to the court. Because of that, any other attempt to use any approach, such as a judicial review, as the NPP used in this manner, is a way of circumventing a proper hearing of the matter where evidence will be properly heard. The NPP, however, opposed this and argued that their case does not deal with the issue of declaring or cancelling results. Their case deals with compelling the Electoral Commission, which has a public duty, a duty to conduct elections, to supervise elections, to collate and declare results. They say
first time I do channel, subscribe my and like and share, share, comment section,